Appeal is a matter of Blacklion Law LLP and Amira Nature Foods Ltd.
Yes. Do you want to take your wigs off?
Yes, please.
Yeah. And your gowns if you want. There is no other court available this morning. So I think we'll keep both doors open. We might hear traffic going along both ways, but if that's all right. And we may be able to move to another court for this afternoon.
It's something of a first world problem. I think we'll
Sorry?
It's something of a first world problem. I think we'll probably be able to survive.
Thank you. And the other thing I wanted to say is that we would hope and expect this case should be finished today, or will be finished today, even if it requires us to sit a little bit late.
Yes.
But that's what we would forecast. Okay.
Yes, I've spoken to my learned friend about timing, and we agree that we should be able to get through it in a day with a fair wind.
Good.
So I'll aim to finish shortly before lunchtime with a view to having that amount of time for reply at the end of the day.
Thank you.
Lord and ladies, we say that this is a rather unusual case. In relation to the claim against the first defendant, Amira, the claim at trial proceeded on a basis, and judgment was entered on a basis, that was wholly unpleaded. Further, despite allowing the claimant to proceed on the basis of a wholly unpleaded case, the judge ruled as inadmissible the best evidence that he had on a critical issue of foreign law that arose out of the unpleaded case. And further, even on its own terms, the judgment is legally incoherent because it proceeds on the basis that there was a breach of an implied term, but then concludes that £300,000 is owed as a debt. And as we've said in the scale of an argument, that is legally incoherent because if there is a breach of a term, implied or otherwise, that can only result in a claim for damages, not a debt claim. In relation to the claim against the second defendant, Mr. Chanana, the court may feel that the position is even more extraordinary, in that it is a claim against a director of a company for inducing a breach of contract by that company, of which he's a director. And yet the case has proceeded without any reference to the rule inside and but. If one looks at it, the pleading from the outset was demurrable. The case wasn't advanced on a proper legal footing at trial, and consequently the analysis of the law in the judgment is simply wrong, and the judgment doesn't contain the necessary findings of fact to support the conclusion that Mr. Chanana was liable for the tort of inducing or procuring a breach of contract. And so both limbs of the judgment, we say, are highly unusual. But of course, I acknowledge the third unusual factor in the case, which is that neither of those objections seem to have been taken at all, or certainly with the vigour that one would have expected from the trial advocate on behalf of the defendants. And obviously that is a point that's relied on very heavily by the claimant, by the respondent to this appeal, perhaps more strongly than indeed the attempt to deal with the substance of the two main thrusts of the appeal. Our position is that this court, on a review of the judgment, should dismiss the claims against both the first and second defendants. Then there's obviously a subsidiary point in relation to the admissibility of the second defendant's evidence, which it doesn't arise if you adopt that course. It may arise if this court were to want to look at the evidence itself or to remit any issues for further consideration at first instance. But in any event, it's a short point, a very short point, we say, where some of the commentary in the White Book appears to be wrong, or at least helpful and misleading. and it may be that this court wishes to say something about it very briefly in any event, even if permission for that part of the appeal is not granted. So if we look at the claim against the first defendant, the claim against Amira, I'll take you to the relevant passages of the judgment in a moment. Although in the judgment there's no reference to the case of Mackay and Dick, the judgment is based on the implication of the Mackay and Dick term of cooperation. If we look at the pleading, however, the pleading of the claim is in the amended particulars of claim, which are in the core bundle at tab 13. As the court will be aware, when the proceedings were commenced, there was a claim under a general retainer and also under the avatar retainer, which is the subject matter of the appeal. The pleading in relation to the avatar retainer commences at paragraph 20, which is at page 125 of the bundle. And the terms are pleaded. And the allegation of breach is at paragraphs 28 to 30. And what is alleged there is that no shares have been issued. And similarly, in paragraph 32, at page 129, it was alleged that the first defendant was in breach of contract in failing to issue the shares in accordance with the terms of the retainer, and indeed the claimant claimed specific performance of the obligation to issue shares in the amount of the fixed fee. There was no reference in the amended particulars of claim to plead any implied term of cooperation, whether based on Mackay and Dick or otherwise. And there was no pleaded allegation, obviously, that the defendant was in breach of any such implied term, no term having been pleaded.
Well, the first sentence of paragraph 9 is that the claimant has, it can't be the claimant, can it? Anyway, has failed to pay the avatar invoices either in cash or in shares or at all.
Yes.
So that's what's being alleged, is that there's been a failure to comply with the obligation to pay £300,000 pursuant to the avatar retainer.
Yes.
At all.
On the basis that shares haven't been issued.
Well, it says has failed to pay the avatar invoices either in cash or in shares at all.
Yes.
Were they paid in cash or shares? They weren't paid in cash. So is it your case that they were paid in shares?
Yes, they were paid in shares because the shares were issued.
In a form that complied with the terms of the avatar retainer?
Well, we say yes. We say that they were issued and that they were restricted, so they bore a legend which meant that they couldn't be sold until the legend was lifted. But we say that it lay in the power of the claimant to lift that legend by obtaining an opinion from a US lawyer saying that they had been issued in return for good consideration.
And the judge's finding was against you on that?
That's correct.
So on the judge's finding, there had been a failure to pay the invoices?
Well, the way in which it works is that the defendant had a right to elect between paying in cash and by issuing shares. Now, the concept of paying by issuing shares is the verb pay is not a particularly happy one to use in that context. It's the consideration for the services which have been rendered. It's fulfilled by issuing shares. We issued the shares. What the judges then found is that there was an implied term whereby we had to cooperate to ensure that the shares could be sold. and we didn't cooperate in what the judges find to be the necessary way. Now, in my submission, it's not correct to characterize that as a failure to pay at all. It is simply even on the judge's findings, it's a breach of an implied term to cooperate.
But sort of one more, going back to the obligation under the retainer was a fixed fee of £300,000.
That's right.
The form in which that could be satisfied, you had an election.
Yes.
On the judge's findings, you failed to comply with that. In other words, you did not pay the 300,000 in either of the forms which you were permitted to do under the terms of the retainer. So you were in breach of the obligation to pay £300,000.
Well, my Lord, I would interpose an extra step. In my submission, Your Lordship is absolutely right to say that we had a right to elect between paying in shares, between paying in cash and paying in shares. We elected to issue shares to pay. And once we are down that path, once we are providing consideration by way of the shares, it is not a helpful exercise to ask whether we have failed to pay or not. The term of payment, the word payment, sits naturally with a cash payment. It doesn't sit naturally with an alternative means of providing consideration for the legal services which have been provided. What we have done is we've elected to issue shares. We have elected shares, but the judges find that we were then in breach of an implied term of cooperation. In my submission, it's not a helpful or correct analysis to say that that means that we have not paid at all, because we have issued the shares, albeit on the judge's findings. We have then subsequently breached an implied term of cooperation. And as I say, there is no allegation in the particulars of claim, amended particulars of claim, either of that implied term or of a breach of it. And it's perhaps worth noting, if one's on page 128, one sees that the particulars of claim were amended in March 2022. One gets that date from the Statement of Truth at page 132. So they were amended just a couple of months before the trial to include the rectification claim, but were not amended in relation to the implication of a term or the breach of an implied term. The claim against D1 continued on the basis that there had been no issuance of the shares.
Is it right, Mr. Russell, though, to say that the judge only found that there was a breach of the implied term? If you look at paragraph 93 of the judgment, the final 3 lines, final sentence, he says, this is a breach of the implied term because you can't sell the shares without the legal opinion, which is not forthcoming. He says, this is a breach of the implied term to which I referred above, and leads to the further conclusion that the first defendant is in breach of the retainer agreement in neither paying the fixed fee nor making the issued shares available for sale. So he's making 2 points there. He's saying there's a breach of implied term because you haven't done what you ought to have done in the sense of assisting, but also actually, you've breached the agreement, the retainer agreement itself, by doing neither thing. You've neither provided shares nor have you paid.
Well, I mean, the judgment says what it says.
Yeah.
The difficulty with that is that it essentially unwinds an election. And there's no, was obviously no pleaded case, there's no explanation in the judgment as to why the breach of the implied term would, in effect, unwind the election to provide consideration by way of shares rather than cash payment?
Well, I think there are two things there, aren't there? Because he does say separately, leaving aside the breach of the implied term, that there's a breach of the retainer agreement in neither paying the money, and I put that in for fixed fee,
Yes.
nor making the issued shares available for sale, i.e. you've not provided something which is the same as the money, and that's what he's saying. But I think you were saying something slightly different. What you're saying, I think, is that once you have made your election, in effect, the obligation to pay the £300,000 falls away. I'm putting words in your mouth, but please explain to me when I have failed to elucidate it properly. That then falls away, and you've taken a right-hand turn, which is marked shares.
Yes.
And once you've taken that turn, marked shares, you can't go back and say, actually, I want the cash. Or I think you're saying, you can't actually go back and say the overall obligation was to pay £300,000. Is that really what you're saying?
It is. It's not a question of saying, of the claimant saying, I now want the 300,000. The election lies with the defendant.
Company.
Yes.
Yeah.
And what I would say is that because it operates by way of an election, once the company has elected to, quote, pay by issuing the shares, then it has gone down that route. It has taken the right turn in your ladyship's analysis, and one cannot go back to the money being owed as a debt. All one is then concerned with is breach of contract, be it a breach of an implied term, or perhaps what the judge had in mind in the last sentence, the last clause of paragraph 93, is something akin to a breach of a warranty in not making the issued shares available for sale. But none of this is pleaded. And of course, what it turns on, this is why the lack of proper pleading is important, is because the proof of breach, once we've taken the right turn, the proof of breach then depends on a proof of US law as to what needed to be done to enable the legend to be removed, or to enable the shares to be available for sale.
Does it really? Because wasn't the evidence that, and I'm not sure about this, whether it's somebody at the company or somebody at the agent says, or the agent says, I won't release them until I have an opinion from counsel from the company. That's right, isn't it?
Well, I wonder if it'd be helpful.
If that's right, then whether or not it's an issue about US law about who could provide it is hardly relevant, is it? Because if the agent won't release them without an opinion from the company, then they're not releasable. End of story.
Well, not if the individual who has provided that single email is wrong, and if. But I wonder if
Wrong in what sense? Because what I'm saying is it's not an issue about the law, it's an issue about the practicality. She says on behalf of her organisation, they will not be released unless.
Well, I wonder if it'd be helpful if I show the court the evidence that was before the court, and then the evidence that was held to be inadmissible by the judge. I was going to take you to the defence and then the reply as well when looking at the pleadings, but I anticipate that the court will have read the pleadings, and I can do little more than point out what...
No, do take your own course. You were going to take us to the defence, where the whole issue of whose opinion it has to be is set out.
Yes. If Lordship doesn't mind, I'll do that, and then I will show you the evidence.
You do
your
what you
Lordship
think
has in
best.
mind. So the defence is at tab 14. And I'll take this quite swiftly, I hope. Page 146. In the bundle is the response to the allegations as to failure to pay. What is pleaded is that the shares have indeed been issued. And then the question of what has to be done next is introduced at subparagraph 6. And the court can see the way in which it's put there. And in my submission, the way in which the judge subsequently approaches this pleading is really to put the cart before the horse. Because what the judge says is, well, you've pleaded, you the defendant, have pleaded this. And therefore, it's for you to make this good. The burden of proof in relation to this is on you. And in my submission, that's the wrong analysis. Because it stems from the lack of a proper pleaded case by the claimant. And the defendant volunteering information in the defence, which it did not need to do to meet the case that was being put by the claimant. The proper analysis was for the claimant to plead there is an implied term of cooperation, to discharge the implied term of cooperation. This is what you need to do. This is why you need to do it. And you have not done it. And properly analyse the burden of proof on all those issues must be on the claimant, who has to plead and prove its claim. The judge in his judgment refers to this as being a response or a pleading on the implied term point, when of course it wasn't, because no implied term had been pleaded at all. And then the proper analysis of this in terms of the defendant's case as it was being pleaded is not as a defence to a claim, but as a separate or freestanding causation argument, if you like, explaining why the claimant hadn't been able to sell the shares, saying this is what the claimant has to do to be able to sell the shares, but not as a necessary part of a defence, because it would only amount to a defence to a claim that had not yet been pleaded.
It also goes on, it's all on the basis that actually, in any event, this is all irrelevant because the payment was contingent on the completion of the bond issue.
Yes, I accept that. That was the defendant's primary case, both in its pleading and at trial, that on a proper construction of the avatar retainer, it was not, as the claimants argued, and as the judge subsequently found, that the fee was only fixed until the 31st of March. The defendant's case was indeed that any obligation to pay or provide consideration was contingent on completion by the 31st of March, 31st of May. And obviously, the judge made that finding as a matter of construction. He also held in the alternative that he would have, if necessary, would have rectified the retainer to that effect. And we don't appeal against that part of the judgment. So in the reply, which is at tab 15, page 166 is the relevant passage. The claimant responds to the paragraphs that we've just looked at. And at subparagraph, it's paragraph 12, subparagraph B, you see that the claimant says that it's unable to admit or deny the matters that we've just looked at. It says the claimant's investigating the true position. And says that the claimant's present understanding is that the shares can only be released when a legal opinion from the general counsel of the first defendant is supplied. And that's the highest that it's put anywhere in the claimant's pleadings. And that tentative plea in the final sentence. There's obviously no suggestion there that, in fact, the cornerstone of the claimant's case, what ultimately the judgment will turn on, is an implied term and a breach of that implied term because the defendant is obliged to provide a legal opinion from its general counsel. But when it came to trial, the claim was obviously advanced on a very different basis from the pleaded case that we've seen in particulars of claim, and was advanced on a basis of a failure by the defendant to provide the legal opinion. Even then, even in Learned Friend's opening skeleton, he didn't put it on the basis of an implied term. The implied term analysis seems to have arisen from the judge himself during the course of argument. Now, the claimant essentially sought to rely on two pieces of evidence. The first is the email exchange with the transfer agent, to which your ladyship has referred. That is in the supplemental bundle at tab 15. And what we have at page 161, so tab 15, page 161, is, in the usual way, reading up the page, an email from Ms. Yazdani, who is, of course, the claimant's principal, Thursday, the 14th of May, at 2:08 p.m. And she says, at numbered paragraph 1, what procedure needs to be followed for the shares to be released? In particular, what information you would have needed to release the shares following their deposit in the account on the 2nd of June 2017. I understand that the only means by which they could be released is a legal opinion from the company itself or its general counsel. Is that correct? Would there have been any other way of releasing them? And what do you need to release the shares inherently in the account? And just pausing for a moment before we look at the reply, bear in mind that this is some 3 years after the event. So this is not a contemporaneous request. What do I need to do? This is very much an historical request. And we have a response that comes back on the email. It's timed at 1922. But given that that is a New York email, it's reasonable to, I think, infer that that's a very prompt reply within 14 minutes, 15 minutes or so. And what Ms. Jones, who, as we understand it, simply has a clerical function at the transfer agent, says, yes, we would require the opinion from the issuer's counsel, representation letter, and letters of instruction. I've put counsel's information below. that can be no more than Ms. Jones's then understanding of what would have been required. And certainly not.
So are you saying actually Miss Jones had no authority on behalf of the agent to say what she was saying? You're not saying that.
No, I'm not saying that.
No.
I'm saying that that cannot be a definitive statement of what, as a matter of US law, was in fact required. It's simply what Miss Jones saying what they probably usually require. There's no suggestion that she is a US law expert.
No, but she is saying expressly on behalf of the agent, we won't do it unless we have this.
That's what she says, yes.
Yeah.
The second piece of evidence that was relied on by the claimant at trial is a web page extract from the Securities and Exchange Commissioners, which is at tab 17 of the supplemental bundle. Certainly in my hard copy, it's been printed out on a single page and is distinctly hard to read. I've printed it out over 3 pages and can pass that up if that's convenient to the court.
Thank you.
And so this deals with 2 sets of securities: restricted securities and controlled securities. Controlled securities are securities issued to an affiliate of the issuing company, so we're not concerned with those. We're concerned with restricted securities. And the relevant section is the last, or the penultimate 2 sections of the extract. On the 3rd page of the little handout that I've passed out. Can securities be sold publicly if the conditions of Rule 1.44 have been met? And you see there it says, even if you've met the conditions of Rule 144, you can't sell your restricted securities to the public until you've got the legend removed from the certificate. Only a transfer agent can remove a restricted legend, but the transfer agent won't remove the legend unless you've obtained the consent of the issuer, usually in the form of an opinion, letter from the issuer's counsel that the restrictive legend can be removed. Unless this happens, the transfer agent doesn't have the authority to remove the legend and permit the execution of the trade in the marketplace. But it then says, in the next paragraph, to begin the legend removal process, an investor should contact the company that issued the securities or the transfer agent for the securities to ask about the procedures for removing a legend. Removing the legend can be a complicated process requiring you to work with an attorney who specializes in securities law. And then, what if a dispute arises of whether I can remove the legend? It says, if a dispute arises about whether a restrictive legend can be removed, the SEC will not intervene. Removal of a legend is a matter solely in the discretion of the issuer of the securities. State law, not federal law, covers disputes about the removal of legends. Thus, the SEC will not take action in any decision or dispute about removing a restrictive legend. And then in the box, at the very end, there is a disclaimer. But that was the evidence that was relied on by the claimant at trial. And quite apart from the disclaimer, one notes that it is not being said here that there is a requirement for an opinion letter from the issuer's counsel. All that is being said is that that is usually the form in which the consent of the issuer is provided. But this document doesn't provide any evidence that an opinion from the issuer's counsel is a requirement.
But it suggests that consent is needed.
Yes, it does. But to the extent that Ms. Jones's email suggested that an opinion was a requirement, if anything, this contradicts it.
Mr. Russell, I just think you're splitting hairs. First of all, this makes clear that consent is required. In the final paragraph, it says, removal of legend is a matter solely in the discretion of the issuer. And then we have a situation in which the agent, who is in control of the shares, says, this is what we require. Now, whether that means that in every case one needs an opinion or not seems to me to be neither here nor there, because in this case that was required. And so it seems to me that the web page makes clear that the issue is in the hands of the company. It's at its discretion, and the company's agent is saying the way we do it is requiring an opinion from counsel for the company. So what is clearer than that?
Well, Lord, my lady, you have my overarching submission, which is that if the claimant wishes to rely on a breach of an implied term, it is incumbent on the claimant to plead the implied term, to plead the content of the implied term, and to plead what it says constitutes a breach of the implied term. Now,
We're going down the implied term route the whole time.
Yes.
But as I mentioned in paragraph 93, it's not clear that the judge was only dealing with an implied term. He also considered that there was a breach of the agreement as it stood. And that was because, I assume, if you read the retainer as a whole, it's an obligation to pay £300,000 by cash or by shares. Those shares, when sold, if they don't make £300,000, the difference is to be topped up. So in the very essence of the terms of the agreement, the shares you are being issued are saleable shares. So that is how I understand the second part of the sentence at the end of paragraph 93.
well, lady, I've made my submission in relation to that, which is that the defendant has a right to elect. Once you've made your election, you're down that path, and that path can only lead to liability on the part of the defendant by way of a breach of a term, by breach of a term, in this case an implied term.
Okay, but the slightly different point that I was making was you've taken your turn,
Yes.
you've opted, you've said it's shares, but the shares are, in the very terms of the agreement, saleable shares.
Yes.
Otherwise, the final paragraph that's quoted of the retainer would make no sense. And in fact, therefore, one doesn't have to go to an implied term. One is in the realms of you've not provided saleable shares.
Well, that's why I said earlier, it may be that the right analysis is that at the end of the paragraph 93, he's suggesting there's a warranty or an express term that they should be saleable shares. You get to the same, ultimately get to the same questions. What needs to happen? Are they already saleable shares or not?
Yeah.
And if not, what has to be done to make them saleable shares?
Yeah.
And what I say in relation to the implied term would hold in relation to that as well.
Yeah.
Because there's no express plea in the particulars of claim that they were not saleable shares. The plea is that they weren't issued at all. That's not right. It's common ground that that's not right. The plea there is that there's no plea that they're not saleable shares, and there's no plea of what was necessary to make them saleable shares.
Yeah, those are your points.
And so whichever of the two analyses of paragraph 93 one goes down, in my submission one gets to the same end point. The original pleading was defective, and it's not supported by evidence of US law that is needed to demonstrate what is required to be done to make them saleable. So whether you approach it in terms of what constitutes a breach of the implied term of corporation, or whether you approach it on the basis of what is needed to be done to make them saleable, it is for the claimant who brings the claim to plead all constituent elements of his case. Now, what the judge did have available to him was the evidence of a US qualified securities lawyer as to what needed to be done. And that was the evidence of Miss Hamilton, which is set out in her 2 witness statements. Just to pick up on her expertise, if we look at her second statement at tab 10 of the supplemental bundle, it starts at page 129. She says, I've been a securities attorney for more than 20 years and have extensive experience in stock transfer agent operations, having served as outside general counsel to transfer agents. So she has worked as counsel for transfer agents. In connection therewith, I authorise an operational manual for transfer agent operations. And she says, in 2016, I was the first person appointed as an independent compliance consultant in action by the US Securities and Exchange Commission to review and implement the operational procedures and compliance of an SEC-registered transfer agent affecting transfers in publicly traded securities pursuant to an SEC administrative order. So the evidence that she provides isn't a 3-line email from somebody in a clerking capacity, nor is it something pulled off the internet, which comes with its own inbuilt disclaimer. This is evidence from somebody who is, in my submission, on any view, a genuine expert in the relevant area. If we then look at the substance of what she says, she deals with this first of all in her first statement, which is in the preceding tab 9, and the relevant passage is at page 124 in the bundle, and it's paragraphs 51 to 58. It's that page 124. Perhaps I could invite the court to read that page.
Sorry, the whole page.
Yes, please. And then she expands on that in the second statement. So in tab 10, page 132. And it's paragraphs 14 to 25. And I'd perhaps invite the court to read those paragraphs in due course. The essence of it, again, is that Ms. Hamilton says that a legal opinion from any US securities lawyer would have sufficed. That's at paragraph 23 of the passage. And the problem that Ms. Hamilton had is that she felt that she was unable to provide any opinion. The opinion would have had to have been to the effect that consideration for the shares had been provided. Because she had negotiated the avatar retainer on behalf of Amira, her belief was that it was a contingency fee agreement and that therefore the consideration for the shares had not been provided.
And indeed that no US securities law attorney would be able to provide such an opinion.
Yes, but that was based on her understanding of the retainer.
This is the evidence that you would have, or you did seek to rely on, in support of your contention that you had complied with your obligations under the retainer. Is that right?
Correct, but it was ruled inadmissible by the judge on the basis that it was expert evidence for which we had no permission.
I understand that. But what I'm looking at is that her opinion was that no US securities law attorney would provide such an opinion. And you accept that such an opinion was necessary for the shares to become unrestricted. So how does that help you?
Well, her opinion that no US attorney would provide the opinion,
yes,
obviously isn't her opinion evidence, isn't explaining what US law is. That part of the statement is explaining her understanding of the meaning of the retainer. Where her evidence is relevant for the purposes of what is required as a matter of US law is her evidence that an opinion from any US attorney will suffice. Now, if she was wrong, as it turned out she was, as to the meaning of the retainer, then it necessarily follows that her assertion that no other lawyer will provide an opinion either is also wrong. That part of her evidence turns on the construction of the retainer, not on an analysis of what US law requires to make the shares saleable.
Right.
Now, we obviously say that given that the question of whether there was either a breach of an implied term or a failure to make the shares saleable arose in the context of an unpleaded allegation by the claimant, it was wrong of the judge to effectively treat as gospel the two pieces of evidence that I've shown you relied on by the claimant, but exclude and rule as inadmissible this evidence from Ms. Hamilton, who is the only person providing evidence before the court that was properly qualified to do so. So those are the pleadings and the evidence. Before looking at the judgment, if I could take the court to Prudential Assurance and Revenue and Customs case, which in my submission is an important case emphasizing why, or explaining why, proper pleadings are indeed crucial. It's in the authorities bundle at tab 11. So authorities tab 11, it starts at page 279, and the relevant passage is at paragraph 12, which starts on page 285. This is a case in which a very long-running piece of litigation. I think that the claim form had originally been issued back in 2003, and it involved numerous claims by Prudential against Revenue and Customs, and the litigation was being managed under a GLO. My understanding from the judgment is that although it was a GLO, the only claimant was Prudential, but it involved a substantial number of different claims by Prudential. And perhaps because of the GLO nature of the case, the pleadings were in very general terms. And what Lord Justice Lewison, giving the judgment of the court, says at D to E is this would simply have been unacceptable in ordinary litigation. We cannot see why it should have been any different in the present case. Although the parties did agree a list of issues, these two were framed in very general terms. And then, if I could take the court to the citation from the judgment of Lord Justice Mummery in the Boak Allen case, he says, while it's good sense not to be pernickety about pleadings, the basic requirement that material facts should be pleaded is there for a good reason, so that the other side can respond to the pleaded case by way of admission or denial of facts, thereby defining the issues for decision for the benefit of the parties in the court. Proper pleading of the material facts is essential for the orderly progress of the case and for its sound determination. Definition of the issues is an impact on such important matters as disclosure of relevant documents, relevant oral evidence to be used at trial. In my view, the fact that the nature of the grievance may be obvious to the respondent, or that the respondent can ask for further information to be supplied by the claimant, are not normally valid excuses for a claimant's failure to formulate and serve a properly pleaded case setting out the material facts in support of the cause of action. If the pleading has to be amended, it's reasonable that the party who has not complied with well-known pleading requirements should suffer the consequences with regard to such matters as limitation. And then he cites the passage from Lord Wolfe in the House of Lords in that case, which had been taken to mean that a rather more relaxed approach might be taken. And at paragraph 16, Lord Justice Lewison says, this does not suggest that basic steps in litigation may be ignored or not taken at all. And similarly, at paragraph 18, at the foot of the page, either way, relevant facts must, in our view, be pleaded. If they are facts generally applicable to all claimants, that they may plead in group particulars, if specific to a particular claimant, they may set out in a schedule. And then, importantly, at paragraph 20, he says, our procedural system is and remains an adversarial one. It's for the parties, subject to the control of the court, to define the issues in which the court is invited to adjudicate. The function is the purpose. This function is the purpose of statements of case. Setting out of a party's case in a statement of case enables the other party to know what points are an issue, what documents to disclose, what evidence to call, and how to prepare for a trial. It is inimical to a fair hearing that a party should be exposed to issues and arguments of which it has no fair warning. If a party wishes to raise a new point, he should do so by amending a statement of case. We were told that by the time that skeleton arguments for trial were served, each party would know what points were an issue. We do not regard that as sufficient. In this case, for example, HMRC's skeleton argument was served about 10 days before the trial started. If, as in fact happened in this case, HMRC wished to argue that the evidence proposed to be called was directed at the wrong issue, 10 days was manifestly inadequate. And then paragraph 21 gives the warning about late amendments. Lord Millais, those are the key passages. I think the entire sidebarred paragraph is relevant. And clearly that emphasises the fundamental importance of proper pleading, identifying in the pleadings, not in skeleton arguments or oral argument at trial, what the case actually is. And as we've seen, there was a wholesale failure on the part of the claimant to comply with that in this case. What that means is that there is a lack of clarity as to what is actually being alleged that is simply inapplicable to a fair hearing. We can perhaps see that just by looking at a short passage in the closing argument. It is in Supplemental Bundle, tab 20, page 376.
Supplemental bundle.
Absolutely. Supplemental, tab 20,
Yes.
page 376. And this is the transcript from day 3 of the hearing. This is Learn Friends' closing submissions. And he's discussing here breach of the retainer. If we pick it up at F, he says, refers to the wording of the retainer, and says, in my submission, this imposed an obligation on, assuming it's right that Amira's authorization is required to remove the legend. This imposed by virtue of that provision, Amira was under an obligation to provide the authorization necessary to remove the legend from the shares after the 6-month holding period had expired, because otherwise Blacklion is not able to sell the shares freely in the open market. And the judge says, you say it's a term which has to be implied. And Learn Friend then says, essentially it's the necessary implication of that provision. This is how the parties envisaged it would work. It was envisaged that Blacklion would be able to sell the shares freely in the open market at any time after the expiry of the holding period. If that involves Amira providing the necessary opinion letter, then Amira must do that. It's failed to do so. So, I mean, here, in the course of just a couple of paragraphs of argument, we've got a really good exemplification of the lack of clarity of what the case actually is. Because, well, is it a requirement to give authorization to the legend? Is it a requirement to provide an opinion letter? What is it? So this all begs the question, what is required as a matter of US law for the shares to become saleable? And none of it has been pleaded.
Well, what actually is being submitted is that the fact that the claimants had to be able to sell the shares freely imposed an obligation to comply with that requirement. And if there was something that meant that they could not be sold freely, then a term of the contract had not been fulfilled.
Yes, but I accept that.
That's what's being submitted.
Yes, but what is required is a proper pleading, a proper identification of what it is said that has to be done to enable the shares to be freely saleable. That has not been done. That's what fair procedure requires. It requires the claimant to say what the defendant has failed to do. And if one goes on, I mean, the position gets even.
Well, so it says Amira was under an obligation to provide the authorization necessary to remove the legend from the shares. That's what it said has to be done.
Well, a number.
You're going to take us to submissions in response, saying, well, that's not open to you because, in some way, this does not form part of the claimant's case.
No, as I said at the outset,
The point wasn't taken.
The point that this was an entirely new case does not seem to have been taken.
Well, an entirely new case is that it wasn't open to the claimants to assert that there was a breach of the obligation to provide shares that were freely saleable in the open market, which imposed by virtue of that provision an obligation to provide the authorization necessary to remove the legend. That's what you're saying. And that your case is that that should have been pleaded, but at the trial it wasn't argued that it should have been pleaded. The factual case was met through the evidence of Miss Hamilton, which, as you say, the judge excluded.
Which the judge, we say, wrongly excluded, yes.
I understand that, but the factual case was met. So if one's looking at fairness of hearing, both parties had the opportunity to obtain and advance evidence on that issue.
Well, in my submission, no, that the defendant did not have a fair opportunity to obtain and adduce evidence on that issue. Because if it had been pleaded, it had been properly pleaded, as it should have been, the pleading should have been, as a matter of US law, this is what you are required to do to make the shares saleable. Then, the fact that the claimant required US law evidence would have been plainly identified, and the defendant would have had the opportunity, in advance of trial, to put in such expert evidence as it saw fit, in compliance with the rules. And the defendant would not have been left in a position at trial where the evidence which it considered that it had was being ruled inadmissible by the judge. We have this asymmetry where the judge allows in and seems to treat it as gospel the email from Miss Jones and the web page extract, but rules inadmissible the evidence from Ms. Woodruff. And the root cause of that, in my submission, is the fundamental failing on the part of the claimant to plead its case in anything like a proper manner. As I say, if one reads on in the judgment, we've already seen it being said, well, assuming it's right that Amira's authorization is required, then conditionally, if that involves Amira providing a necessary opinion letter, we then move on to cooperation, and essentially the judge says, well, where has Amira said that it's not going to cooperate? That's a D on page 377. Where does it say that in terms? Where does Amira say that in terms? And my friend says, in the pleadings. And so the allegation of breach seems to be principally in relation to what was pleaded. Yes, by Amira. And that then translates into what in our submission is an entirely unsatisfactory judgment on this issue. If we go back to the judgment, which is in the core bundle at tab 11, the judgment starts at page 84. The judge identifies the issues in paragraph 2 of the judgment. And you'll note that in identifying 3 primary issues, the first is construction of the retainer, whether it's conditional on completion of the bond issue or not. Then, second issue is rectification. And then thirdly, he says, if the claimant establishes a breach, a further question as to the possible liability of the second defendant towards the claimant. But in his in his identification of the issues, he doesn't even identify as an important issue the question of whether the first defendant was in breach of an implied term. In my submission, that must flow from the lack of proper analysis in the pleading. And it illustrates the dangers that the Court of Appeal alluded to in the Prudential case, because there's no proper analysis of whether there was an applied term, what the breach of it was, and if so, what the remedy might be. His treatment of the breach issue is at paragraphs 85 to 93. I'm sure the court will have read. And again, in my submission, there is no proper analysis. Well, first of all, no recognition at all that he is dealing with a claim that has not been properly articulated or pleaded in the amended particulars of claim. And secondly, a distinct lack of clarity as to what it is being said the defendant should have done.
Yes.
In my submission, one comes away even from the judgment with no clear identification of what it is said that Amira should have done. And there's obviously reference to an opinion from Amira's legal counsel. Ms. Hamilton has said in her statements very clearly that she would not provide a legal opinion that the legend should be removed, because in her view, on her understanding of the retainer, consideration had not been earned. So in those circumstances, faced with a legal counsel who says, well, I can't provide an opinion because I don't agree that consideration has been provided. What is it being said that Amira were supposed to have done? This, again, it all stems back to the lack of any proper articulation of the case at the pleading stage. And that has led to, we say, first of all, the incorrect and unfair exclusion of Ms. Hamilton's evidence, leads to the judge proceeding without the evidence that he needs to reach any proper conclusion as to US law, which is a necessary element in holding that the shares aren't saleable, and it leads to a judgment that is simply unjust. And for those reasons, the judgment against the first defendant should be set aside on appeal.
Yes.
My Lord, we have an alternative submission in relation to the claim against D1, which is that in any event, even if the finding that there was a breach of an implied term stands, or on the analysis that there was a failure to provide saleable shares, the shares not become saleable. Those are both breaches of contract, with the result that the only available remedy is damages rather than a judgment in debt. And the consequences of that is that damages would have to be assessed, or should have been assessed by the trial judge. It's not a case of somebody saying, well, it's 300,000. Prima facie, the measure of damages for breach would be the difference between the value of the shares at the date when the claimant would have sold them. So in other words, what the claimant would have realised if there had been no breach, less any residual value.
That depends on you going behind the judge's finding that the shares were not saleable. So what we're supposed to conclude that the judge was wrong to find that the shares were not saleable.
No, well, even if one accepts that finding and holds that the residual value was nil, the damages would not be the value of the shares when they were issued. The damages would be the value, the proceeds of sale that the claimant would have realised when she would have sold them if there had been no breach.
Sorry, the shares aren't saleable on the judge's findings.
Yes.
So how do you get to? I don't see how you get to that at all.
No, because the no breach counterfactual is that they would have been saleable, and the question then is, what would the claimant have realised from the
there should have been an argument raised of a counterfactual saying that the judge should have treated them as saleable at a certain date.
Yes.
Right, okay. And this comes back to the fact that it wasn't pleaded, so none of this is argued, so there's no evidence. Exactly. Right.
Exactly.
What about the retainer that simply states that the firm will charge the company a fixed fee of £300,000? If you don't pay the fixed fee by either of the options available to you, why does that not mean there is a debt in respect to the fixed fee of £300,000?
Well, it's the right turn point.
I see. So it all hinges on the fact that you've selected an option means that it stops being a debt due in £300,000 of £300,000.
Correct. There is. We have the right to elect the means by which we provide.
Sorry, to stop you. You don't have the right to elect. You have the right to choose how to pay. If you don't pay, why is the failure to pay the fixed fee of £300,000 not a debt?
Well, because we say we say, having elected to provide consideration by issuance of shares, we have done that. We have issued the shares, and if the shares are not saleable, that the right analysis is that is not a failure to provide any consideration at all, a failure to pay, putting that in inverted commas. It is a breach of contract in failing to ensure the shares that we have issued are saleable.
Well, the company shall have the option of paying, and you've said that's an odd word. It might not be an odd word. It actually might be rather an accurate word. You've got to pay the sum of £300,000 in one of two ways. On the judge's finding, you did neither. So you haven't paid the fixed fee of £300,000.
Well, we say we do say that the legal analysis that we have not paid at all is wrong.
I see.
Because we have issued the shares.
I see.
So it's the fact that we've issued the shares
means that you have paid.
Yes, and there's a breach of contract.
Right.
By failing to make the shares saleable.
I see.
I'm sorry. If that...
So your submission is that you did in fact pay by the issue of shares.
Yes.
Right.
That is the right turn.
Yes.
And everything else then is a matter of breach.
And if the judge was right to find that you didn't pay by the issue of shares, would he also have been right to conclude that there was a debt due in the sum of £300,000?
Lord, no, I couldn't sustain an argument that if there had been no payment at all, there was no debt. But my submission is that the judge's judgment is premised on a breach analysis.
If we proceed with that, sorry, my voice, if we proceed with that breach analysis and actually look at the terms of the retainer,
Yes.
it goes on to say quite a lot
Yes.
about making sure there is broadly £300,000 of value
A top-up.
provided.
A top-up, yes.
So I'd like to understand how that fits with what you're saying about the breach analysis.
Well, as a matter of proper analysis, the damages that the claimant is entitled to must be let's unwind. The breach is not making the shares saleable. The consequence of the breach is the claimant's inability to claim the shares. The damages to which the claimant is entitled must be the value that it would have been able to sell the shares for, the price that they would have been able to obtain on the selling of the shares.
Well, my point is, doesn't the analysis go further than that?
Well, there may then be a separate claim for a top-up. The claimant could have pleaded. Let's think it through. The claimant could have pleaded, if you had not been in breach, I would have been able to sell the shares and would have sold the shares in September 2017. Let's say the value of the shares had gone down. The value of the shares then was only 200,000. So the damages for breach are 200,000 because that is the price that had been realised. The claimant may then have gone on to plead, but in addition, I would be entitled to the top-up that your ladyship refers to. But again, that's a whole series of steps that have not been pleaded.
But why do you need to go into all that detail when the contract says in terms, both parties intend that what you will end up with is neither more nor less than £300,000?
Well, it's a legally rigorous analysis rather than simply saying ultimately you are entitled to 300,000. You've got to identify the route by which you get to that conclusion. And it may have a significant impact on, for example, the calculation of interest, the dates at which interest runs, for example. Unless there's something else in relation to that point, the only final point I had in relation to the claim against D1 is indeed the interest point, which is that if the right analysis is that it should be a damages claim rather than a debt claim, then contractual interest doesn't apply. As I read my friend's skeleton argument for this appeal, he accepts that there's no contractual right to, and very helpfully my friend nods, there's no contractual right to interest at the contractual rate on damages. He says that statutory interest should be calculated at the contractual rate. In my submission, there's no basis for that. One can draft interest clauses in contracts so that they do apply to damages claims. That hasn't been done in this case, and the normal commercial court rate of 2% of the case should apply. So, unless I can assist further in relation to the claim against the first defendant, I propose to move on to the claim against the second defendant, which of course is the tortious claim. Everything I've said in relation to D1 applies in relation to D2, because
Yes.
if there's no basis of a
Yes.
finding of breach,
Yes.
then there can be no claim for an inducement. And as I say, it is rather remarkable coming to the case afresh as I did, to find a claim against a director for inducing a breach of contract by his company without any reference to the well-known rule in Said and Butt at all. I propose to take the court to the relevant authorities, but I anticipate that most, if not all of them, will be well known to the court, and I'm perfectly happy to be hurried along if the court wishes to hurry me along.
But you do accept that this point was not taken below at all?
Yes. It doesn't appear anywhere in the pleadings. It doesn't appear anywhere in the opening skeleton arguments. And it doesn't appear anywhere in the oral argument. There is, in my learned friend's written closing note, there is a very brief reference that I perhaps should show the court now. It is in the supplemental bundle, tab 3. In the very last paragraph, and you'll see that there's a reference there to he wasn't acting bona fide and within the scope of his authority. But no citation of any of the relevant authorities, and no identification of that as being a fundamental element in the tort, and a matter which was incumbent on the claimant to plead and prove. My learned friend, it says that he did raise it orally as well. If I've missed a reference in the transcripts, we'll provide the court with relevant reference. And then I can deal with that in reply if necessary. So if we start with Side and Butt itself, that's at tab 1 in the authorities bundle. As the court may recall, this is the case where Mr. Butt was the chairman and managing director of Palace Theatre. The claimant was a Mr. Said, who was a Russian gentleman of independent means, who appears to have had some beef with Mr. Butt. He wanted a ticket for the first night of a play. He knew the theatre wouldn't sell him one, so he got a Mr. Pollock to buy the ticket on his behalf. And when he pitched up, Mr. Butt refused him entry, and Mr. Said sued him under Lumley and Guy principle for inducing the company to breach the contract. Now, the case, in fact, was decided on the basis that because of the deception in using Mr. Pollock to buy the ticket, there was no contract at all. So, as sometimes happens in English law, the fundamental principle, the rule inside and Butt, in fact, arises obiter in the case. I don't think anybody's going to suggest that it's not good law simply because it was obiter in the judgment of Mr. Justice McCarty. The key passage, which again I'm sure the court will be familiar with, is on page 12 of the bundle. page 506 of the report, at the bottom of the sidebarring, I hold that if a servant acting bona fide within the scope of his authority procures or causes the breach of a contract between his employer and a third party, he does not thereby become liable to an action on tort at the suit of the person whose contract has thereby been broken. I abstain from expressing any opinion as to the law which may apply if the servant, acting as an entire stranger or wholly outside the range of his powers, procures his master wrongfully to break a contract with a third person. And the way in which the rule is commonly expressed is that the director will not be liable unless he is acting mala fides without the scope of his authority. Now, importantly, it is necessary for the claimant to plead and prove that the director is acting mala fides and without the scope of his authority. And if he does not do so, then the pleading is demurrable. And that is clear from the decision of the Court of Appeal in Holding Oil Mark Rich, which is a 1996 decision, which is at tab 2, page 14 of the bundle. Lord Justice Aldous gave the leading judgment. Sir John Balcom gave a short concurring judgment, and Lord Justice Norse agreed with both judgments. We can see from the first paragraph of the judgment at page 15 that it was an appeal from a strikeout application, and appeal and cross-appeal, in fact, that the part of the strikeout application that had been successful at first instance was the striking out of the inducement of breach of contract claim against the fifth defendant. And the relevant paragraph, the relevant passage, starts at page 41 of the judgment. And perhaps I could invite the court to read from the foot of page 41 through to the foot of page 43.
Yes. So an application would be made to strike it out on the basis that it was defective.
Yes, and,
Yep.
and it was struck out.
Yep.
It's not incumbent on the defendant to plead that he was acting in good faith and within the scope of his authority. It is a requirement for the claimant.
I understand that. The point is that it was raised
Yes,
at
it
the
was.
pleading stage.
It was, yes.
Yeah. And the Court of Appeal also said that the wouldn't have been right to give the plaintiffs an opportunity to seek to amend their pleading.
Yes.
Which might have been another way of dealing with it. Yes.
And that approach has been followed in a number of cases. We put the decision of Mr. Justice Closter in Crystal Ends in the bundle, which is to the same effect. The authority I will take you to is the IBM and LZ Labs case, which is a very recent decision. It's at tab 15 of the bundle.
Yes.
And the relevant discussion is at page 387 through to 390. And this discusses both the holding oil decision and the decision of Mr. Justice Lane in Anchusis, which addresses the question of what it means to be acting mala fides without the scope of the director's authority. And so at paragraphs 28, 29 and 30, Mr. Justice Eyre rejects any suggestion that holding oil has been overtaken by OBG and Allen or should be treated with any caution following the decision in OBG and Allen. Paragraph 29, the judge says there's no basis for the suggestion that the decision of OBG and Allen in some way superseded the principle derived from side and but and its consequences for the proper pleading of the claims. It's apparent from the decision holding oil as to the elements which may be pleaded followed from the Court of Appeal's assessment of the elements necessary for liability to be established and form the requirement for those elements to be pleaded if a cause of action was to be shown. That assessment is binding on me and there's no basis for the suggestion it's not of general application. And then at paragraph 31, he cites Anchusis. And the thrust of Anchusis is that what matters is that a director is acting mala fide in bad faith towards the company of which he is a director, not towards the claimant. Perhaps I could invite the court to read paragraphs 31 through to 36. And then I'll highlight some key passages.
Yes.
And so, just points to highlight. It's expressly said in paragraph 36, and it's obviously right. The general rule is that a director is not liable in tort for inducing the company of which he or she is a director to breach a contract. So the general rule is no liability for inducing a breach of contract. And we see that from the way in which it was put inside and but itself. And so what we're looking at is an exception to the general rule. As I say, the focus, the paragraph 32, the foot of the page, the focus of the inquiry is as to whether the director acted bona fide within the scope of his authority, is focused on the director's duties to the company, so his own company, and not to any third party. The question is not whether the director was acting in bad faith towards the third party whose contract with the company is to be broken, but rather whether the director is in breach of his or her duty to the company. And you see the reference to the test being whether the relevant question is whether the director was seeking to force the company to do something contrary to its own interests. Self-evidently, it's the case that deliberately directing a breach of contract isn't bad faith towards the company itself, because it's a necessary element of the tort that the director induces the breach, knowing it to be a breach. The focus is on, in Antusis, is on very serious breaches indeed that are ultimately disastrous or have catastrophic consequences for the company. That was a case in which Antusis was a gangmaster case in which the defendants were essentially exploiting workers purely for their own profit, and when that was exposed, it obviously destroyed the reputation of the company and had a dramatic impact on the company. In Antusis, one of the elements that went to the seriousness of the breach was that it was obviously a breach of statutory employment obligations. And the fact that the breach is not merely a breach of contract, but also involves a statutory element, may be a relevant consideration. But that of itself is not sufficient for a finding that the director was acting mala fides towards his own company and without the scope of his authority. So it's the exception only applies in my submission, truly exceptional cases where the consequences of the breach are extreme and will do severe damage to the company. This case, by contrast, is a perfectly vanilla breach of an obligation to pay a service provider. There's nothing remotely exceptional to take the case out of the general rule that a director is not liable for inducing a breach of the company of which he is, by the company of which he is a director. So we've already looked at the. Well, it might be helpful to take the court to the pleadings specifically in relation to the breach against the second defendant. So we're back in the core bundle at tab 13.
Mr. Russell, I apologise to the court and to my colleagues, but I'm going to have to undo my gown. Thank you. I mean, no disrespect to anyone.
No, not at all. It's just, normally in films, the hero sort of removes the ordinary clothes to reveal the gown, and in this case it's
just blue underneath. I'm sorry.
It's operating in reverse. I don't know if there's a little sort of phone booth out there that you go into and come out as.
Thank you, Mr. Russell. Yes, you were taking us to Divider 13.
Yes, and the plea against the second defendant is at section B, page 130.
Yes.
The point I make is the pretty obvious one, that the necessary element of the cause of action is not pleaded there or anywhere else, and nowhere in the argument is there any analysis of the facts that would lead to a finding that this is an exceptional case, leading to liability on the part of the director. In the judgment,
So the defence, you're taking us to the defence as well, I think, weren't you?
the defence on that point is at page 141. I beg, yes, I'm so sorry, 149. I mean, obviously I accept that what is pleaded there is a defence based on OBG and Allen knowledge grounds. There is no identification that the pleading against it is defective, nor any positive assertion that directors are not liable unless ... I'll come on to the consequences of that in a moment.
Yes?
I was then going to take you to the judgment, which is in the same bundle, in the core bundle, at tab 11.
Yes?
And it's paragraphs 94 and following. Go to page 109. I claim against the second defendant. The case is put on the basis that he has de facto control over the first defendant.
Yes.
And then the law sets out a long passage from OBG and Allen, refers to Clark and Lindsell, identifies, I'm not 96, identifies that the authorities cited for the proposition from Clark and Lindsell aren't of a director inducing or procuring a breach of contract. But then says, I see no reason why a director cannot in principle be liable for the tort of inducing or procuring a breach of contract by the company in an appropriate case. I mean, the judge, in fairness to the judge, he doesn't appear to have had any of the relevant authorities cited to him. But he seems to be here proceeding on the basis that the question of whether a director can be liable for the tort of inducing or procuring a breach of contract is some novel one that he's got to approach as a matter of first principle, which is obviously fundamentally wrong given the learning that there is in relation to the rule inside and but. And the fact that such liability is in principle possible, but it is the general rule, as we've seen in IBM, is that a director is not liable, and that there is an exception to the general rule. So the judgment proceeds on a basis that is woefully incomplete and therefore wrong. And the judge then analyzes the facts, unsurprisingly focusing on the question of the second defendant's knowledge. But again, there is no attempt to establish that the case falls within the exception. In my submission, it's perfectly clear that it could not fall within the exception if it had been addressed. Now, I obviously accept, as I have done already, that this wasn't a point that was taken on behalf of the second defendant, either at the trial or prior to trial. So, what are the consequences of that? Well, first, the starting point, we say, is that whatever criticisms can be made of the second defendant's counsel in not taking the point, the fundamental obligation must always be on the claimant to plead a non-demurrable cause of action. And the claimant has failed to do that. Secondly, there is an obligation on all counsel to draw relevant authorities to the attention of the judge, so that the judge does not proceed on an incorrect footing as to the law. That does not appear to have been done in this case. And as a consequence, the judge has proceeded on an incorrect footing. We are left with a judgment that is plainly, in my submission, wrong as a matter of law. And this court should not allow that judgment to stand. And I say that this is different from the general run of cases where new points are taken on appeal, because it is not a case of a defendant seeking to run its own positive case for the first time on appeal. It is a case of a defendant, albeit belatedly, of course I accept, pointing out that the claimant's case is demurrable, is fatally flawed, and that the legal analysis in the judgment is wrong as a matter of law. If one were to apply the principles from cases like Singh and Das and others to this case, one asked, well, what would have happened if the point had been taken at trial? And in my submission, the only possible conclusion is that the claimant would have been required to make an application for permission to amend, because it couldn't proceed on a demurrable pleading. And that application would have been refused because it was being made so late in the day, in circumstances where the second defendant would have no opportunity to deal with it, being as it was out of the country. And because it would have had no prospect of success in any event, because there is nothing exceptional about this case. There is nothing that leads to the conclusion that Mr. Chenana was acting mala fides towards Amira and without the scope of his authority. It's a perfectly vanilla refusal to pay a bill which he doesn't want to pay. But again, one comes to the fundamental point that this appellate court is faced with a judgment in which a section headed "The Law" sets out an analysis of the law that is incomplete and wrong. And that judgment, as I say, should not be allowed to stand.
Right.
That's what I wanted to say in relation to the claim against the second defendant, unless I can assist the court further in relation to that.
No, thank you.
That leaves the exclusion of the evidence point.
Yes.
I've dealt with that in writing. Unless the court wishes to hear my oral submissions in relation to that, I'm happy to stand on what I've said in writing.
Do you have any more questions on that? Do you have any more questions on that? No, thank you.
As I say, the only point I make in relation to that is not on the merits of the matter. It is simply that the note in the white book is at best misleading. In my submission, the course that the judge took was plainly wrong, and it may be useful if the court were to give even obiter guidance to prevent similar mistakes occurring.
I think we're usually reluctant to give obiter guidance because it's obiter guidance.
I fully understand that, but and this is obviously somewhat divorced from the merits of the case itself.
Yes.
It would be disappointing if the opportunity were here to correct what we say is an error of principle, and then the judgment were to be the judgment below were to be cited or followed in another case. Whether the court wishes to do that is obviously
Thank you.
entirely a matter for the court.
Should we stop now and start again at 1:45 in the new court, assuming we can get to the new court, or what do you want to do? I'll give him 10 minutes. Are you all right to go? What? Assuming the new court's available, should we do that? Yeah. We're thinking of stopping now and starting again at sort of 22:02 on the basis that the new court hopefully will be available by then. And anyway,
I'm very
not
grateful
to give you the opportunity to speak now. So we'll stop now and start again at 22 in, I think it was mentioned as 69, but I'm not sure, so we'll have to find out. So if you can wait here for a moment, and then you'll be told which court hopefully we're moving to. Thank you.